I'm audible, ma'am.
Good evening, everybody. Ma'am, good evening.
Good evening.
Ma'am, I'm audible.
Yes.
Okay. Before we start, we deeply mourn the demise of Mr. V.T. Gopalan, former Additional Solicitor General and Senior Advocate. He was one among the eminent lawyers the Madras Bar had ever had. More than that, he was a kind-hearted gentleman. I feel it's a personal loss to me. Today's topic, I would like to dedicate to the departed soul. Ma'am, the topic of today is Art of Cross-Examination, to be addressed by Senior Counsel Mrs. Rebecca John. You can find her in all high-profile cases. She will be present. An eminent lawyer, one of the fantastic trial lawyers in India. Ma'am, I welcome you and thank you for accepting our invite.
Mr. Gopalan. I didn't have the privilege of knowing him, but from what you have said, he was an eminent lawyer, and losing someone from our fraternity is always deeply painful. So my deepest condolences to the family of Mr. Gopalan. Moving forward, I've been asked by Mr. Ravindran to address this very august gathering on the art of cross-examination. I don't know whether I'm addressing people who already know the art of cross-examination, but I very humbly put forward this presentation as a practitioner of the law. Now, cross-examination is one of the most visible aspects of a criminal trial, thanks to its pervasive presence across popular culture. For a young lawyer, it can be exciting and yet a daunting aspect of a criminal trial. The significance of cross-examination in criminal trial is perhaps best summed up in the following paragraph, the celebrated book, The Art of Cross-Examination by Francis Wilhelm. And I quote, the issue of a cause rarely depends upon a speech, but seldom even affected by it. But there is never a cause contested, the result of which is not mainly dependent upon the skill with which the advocate conducts his cross-examination. Now, I'll begin this by asking myself a question. To understand the relevance of cross-examination, we must understand the meaning and relevance of evidence as a whole. What is evidence? Evidence is described in Section 3 of the Indian Evidence Act, which defines and includes evidence to mean all statements which the court permits or requires to be made before it by witnesses, and all documents, including electronic records, produced for the inspection of the court. Further, evidence can be divided into two further categories. Oral evidence, and that you will see in sections 59 and 60 of the Indian Evidence Act, and documentary evidence, which is available from section 61 onwards. There is also direct and indirect testimony. There is also circumstantial evidence. Now, direct testimony is testimony of witnesses who perceive facts or the production of documents which constitute facts which are in question, and indirect is evidence that gives rise to a logical inference that such facts exist. Now, evidence as a whole, when you look at evidence as a whole, it includes examination in chief, cross-examination, as well as re-examination. In a landmark judgment of the Delhi High Court, Vipin Kumar versus Customs Department, 2001 Criminal Law Journal 1288, the Honorable Division Bench of the Delhi High Court said that the words all statements include examination in chief as well as cross-examination subject to the permission of re-examination. Now, what is examination in chief? What is cross-examination? What is re-examination? This has been defined in section 137 of the Indian Evidence Act, where examination in chief is defined as examination of a witness by a party who calls him cross-examination by the adverse party, and re-examination by the party that calls him originally. When I address cross-examination as a tool in a trial, I look at some of the things which are brought out in examination in chief. What is the object of the examination in chief? The object of examination in chief is to place the witness's deposition before the court and is conducted by his own counsel. The task of the defense counsel begins during examination in chief and not just during cross-examination, at which stage lawful objections can be raised at the time of recording the examination in chief. Now, what are the illustrations of objections which can be taken during the recording of examination in chief? Hearsay evidence. Section 60 of the Indian Evidence Act states the evidence of a witness as to what was said to him by another person is not admissible unless that person himself deposes to that fact as a witness. Because all evidence, as I said earlier, must always be direct, and hearsay is no evidence. There is, of course, an exception to the rule of hearsay, and that is defined under Section 6 of the Indian Evidence Act, which is the rule of res geste. I will quote from a judgment of the Supreme Court, Kishan Kumar Malik versus State of Haryana, 2011, Volume 7, SCC, page 130, paragraphs 33 to 37, where the Supreme Court says, and I quote, Section 6 of the Act has an exception to the general rule whereunder hearsay evidence becomes admissible. But as far as bringing such hearsay evidence within the ambit of Section 6, what is required to be established is that it must almost contemporaneous with the acts, and there could not be an interval which would allow fabrication. In other words, the statement said to be admitted as forming part of res geste must have been made immediately with the act, immediately thereafter. Admittedly, the prosecutrix had met her mother Narayani and sister soon after the occurrence. Thus, they could have been the best res geste witnesses. Still, the prosecution did not think it proper to record their statements. So res geste, that is Section 6, is an exception to the rule of hearsay. Another objection that can be raised during examination in chief is with respect to mode of proof. Documentary evidence of a secondary nature can only be produced when the non-production of the original document is accounted for, or the factual foundation for tendering secondary evidence has been laid out as defined in Section 65. For example, photocopies of original documents are inadmissible in evidence, and an objection can be raised if the original continues to remain with the side producing the witness and the document. Likewise, objections can be raised with respect to secondary evidence. You're all familiar with the certification under Section 65B. Producing electronic evidence without a certificate under Section 65B, or along with the defective one, can also be objected to. Besides, of course, paying attention to such a certificate during cross-examination. For example, printouts of emails, WhatsApp messages, printout of FIR, CCTV footage extracted from the memory card of a digital video recording. All of these, if unaccompanied by a 65B certificate, there can be a preliminary objection made at the time of examination in chief itself. Of course, the parent judgment on this aspect is Anwar PV versus PK Bashir, 2014, Volume 10, STC 473. This judgment has been somewhat diluted since its passage by other benches of the Supreme Court. Nonetheless, because 65B exists in its present form on the statute book, objections with respect to admissibility of electronic evidence must be raised at the appropriate time. It's also well known that the mere marking or exhibiting of a document does not amount to proof. So merely because you've marked a document or you've exhibited it, it cannot or should not be confused with proof. And this is the judgment of the Supreme Court in Seth, Taraji, Kimchand, and others, 1972, volume 4, SEC 562. Many questions can be raised about the competency of the witness in examination in chief itself. Leading questions are not permissible under sections 141, 142, and 143. And the parent judgment on this is Varki Joseph versus State of Kerala, 1993, SEC Criminal 1117. A witness, by and large, should never be encouraged to give his opinion, unless, of course, he is an expert witness. There is a separate category of expert witnesses, which are dealt with in the Indian Evidence Act, 45 to 51 of the Indian Evidence Act, and certain documents are admissible in evidence even if the witness does not appear. For example, the documents mentioned in Section 293 of the Code of Criminal Procedure. So as a general rule, witnesses must state facts according to what he saw, what he perceived, or what he heard, and is not entitled to give any opinion about the matter. However, expert witnesses are called in essentially to give their opinion, and therefore those witnesses can do so, and their evidence is admissible in evidence. As I said, under Section 293, reports by certain experts are admissible. It is at the discretion of the court whether to summon the expert or not. 161, Section 161 of the Code of Criminal Procedure is not substantive evidence. And therefore, when the prosecutor or the opposing side seeks to bring on record the contents of the statements recorded under Section 161, objections must and should be raised. I will refer to a judgment of the Supreme Court, Rajinder Singh versus State of UP, 2007, Volume 7, SCC 378, where the Supreme Court has held in Para 7 that the High Court has basically relied upon the statements of 6 witnesses, which had been recorded by the investigating agency under 161 CRPC, to record a positive finding that the respondent could not have been present at the scene of the commission of the crime. A statement under Section 161 CRPC is not substantive evidence. In view of the proviso to subsection 1 of Section 162 CRPC, the statement can be used only for the limited purpose of contradicting the maker thereof in the manner laid down in the proviso. Disclosure statements. Disclosure statements, also colloquially known as confessional statements, are per se inadmissible in evidence. And there is law from the time of the Privy Council on this, but the most important judgment is a judgment of the Supreme Court in Prabhu versus State of UP, 1963 to SCR 881, where the Supreme Court said that the disclosure statement of the confessional statement is inadmissible in evidence, except for the portion which leads to the recovery of a fact or thing. There is a tendency among prosecuting agencies to exhibit disclosure statements. In my view, that is improper, because what you're doing is exhibiting an inadmissible piece of evidence. However, if pursuant to the disclosure statement, there has been a recovery of a fact or thing, then clearly that recovery can be a subject matter of evidence. The Supreme Court has said that they are of the opinion that courts below were wrong in admitting in evidence the alleged statement of the appellant that the axe had been used to commit murder, or the statement that the blood-stained shirt or dhoti were his. If these statements are excluded, and we think they must be excluded, then the only evidence which remains is that the appellant produced from the house a blood-stained axe and some blood-stained clothes. The prosecution gave no evidence to establish whether the axe belonged to the appellant or the blood-stained clothes were his. Now, the reason why I highlighted these objections in this part of my address is because cross-examination is not an isolated part of the duties of a defense counsel. Cross-examination must be interlinked with examination in chief. And examination in chief gives us lawyers the right to make these valid objections, and those objections must be taken. It is indeed an extension of what we will do in cross-examination. So evidence must be looked at holistically. If we sleep through the examination in chief and permit inadmissible evidence to be brought on record, we are diminishing our own case, and we may not be able to pull back during cross-examination. So the idea behind this part of the address was that cross-examination cannot be isolated as one exercise. It must be interlinked with the examination in chief. And while the examination in chief is on, all lawful objections which are permitted under the Evidence Act or the Code of Criminal Procedure must be taken. And that is indeed part of the duties of a cross-examiner. Coming to the actual act of cross-examination. What is the significance of cross-examination? What is its objective? Cross-examination is a questioning of a witness by the counsel from the opposite side. The objective of cross-examination is to test the truthfulness of the facts stated by the witness in examination in chief, or to attack the credit of the witness, or to prove facts favorable to the other side, or unfavorable to the side that has produced the witness. The importance of cross-examination can be understood from the fact that the testimony of a witness cannot be considered evidence unless an opportunity has been granted to the other side to cross-examine him or her. I will briefly refer to Section 33 of the Indian Evidence Act. Section 33 envisages a situation where in previous proceedings or in proceedings of this, or on the same proceedings, evidence is recorded, and that is admissible in evidence only if during those proceedings the opposite side had an opportunity to cross-examine such witness. So therefore, any evidence deholds of cross-examination unless you give up your right of cross-examination will be tainted because, as I said earlier, evidence consists of three components: examination in chief, cross-examination, and re-examination. So cross-examination has a threefold objective: to test the veracity of the witness, to discover who he is and what his position in life is, and to shake his credit by injuring his character, or the answer to such questions might tend to incriminate him. Now, how do you prepare for cross-examination? As a defense lawyer, one must have a crystal clear understanding of the case of the prosecution, the defense of the accused, and how the testimony of the witness fits into the case. A crucial part for preparing cross-examination is identifying whether the witness is relevant to the case of your client or not. For instance, in a case involving multiple accused, different witnesses may testify on the role played by different accused persons. It is as much a skill to identify whether to cross-examine the witness or not as it is to actually conduct the cross-examination. Having done this groundwork, the counsel can then attempt to prepare questions that can be put to the witness in cross-examination. It is therefore crucial to identify the purpose that the witness serves for the other side and the purpose for which she or he may be relevant for the cross-examiner's client. This will then determine the strategy to be adopted by the cross-examining counsel for that witness. It is a golden rule of cross-examination that the cross-examiner should only ask those questions whose answers you know in advance. I always, while preparing questions, tell my team what are the possible answers the witness can give. And if in first instinct, the answer seems to incriminate my client, I would rather not ask that question. On the contrary, if the answers were such that will not incriminate my client in any manner, to the best of my understanding, I would go ahead with asking the question. Asking a question with an unknown answer is fraught with risk. While such an answer might be favorable to the cross-examiner, it is possible that the answer might also be undesirable to the extent that it might even be fatal to the cross-examiner's case. A perfect example is presented in the penultimate question put by the prosecutor to the defense witness in the movie Anatomy of a Murder. Believing the witness to be the lover of the deceased, the prosecutor questions the witness. However, the witness reveals that she's actually the daughter of the deceased, born out of wedlock. This demolished the entire case of the prosecution, and the accused was acquitted. Having said that, counsels do take calculated risks from time to time, but even then, it should be attempted only with the knowledge that you are capable of controlling any damage if such damage was to surface. Another golden rule of cross-examination taught to me by my seniors is that more important than knowing which questions to ask a witness is knowing which questions not to ask. This is because some questions will result in answers detrimental to your client. By asking such a question, which ought not to be asked, the cross-examiner runs the risk of bringing on record such answers which will negatively impact your client's case. Despite this preparation, it is worth noting that the witness is human and may answer questions differently from what was anticipated by you. This could be inadvertent, this could be due to lapses of memory, or because the witness is lying. The ability to think on one's feet and to respond to an unexpected answer by changing one's approach and pulling back midway through the cross-examination is also cultivated through skill, practice, and experience. Before going into actual cross-examination in a court, particularly if the offense is one like murder or which are IPC-related offenses, there are certain other aspects of preparation which I'd like to highlight. I often insist that my team does a site inspection, see whether the evidence that the witness is proposing to make is probable or not through a site inspection. Ask your client any information about the witness. Always remember, and I say this very often, at the end of the day, it is the story of your client that you're putting forward through evidence. It's not possible, at least not very often, to manufacture a story. Normally, interactions with your client before a witness comes on the stand brings out valuable information, either about the incident or about the witness himself. And that information can be made part of the manner in which you question the witness or in the questions themselves. Do a background check on the witness. And today, it's very simple with respect to some of the more, some of the witnesses in more high-profile cases to do background checks. In a case of some national significance, which I did, well, not national significance, but it was of interest to a lot of people. I noticed that some of the witnesses that were being produced by the other side had a history which was contrary to what was being projected by the side producing those witnesses. And this was available on public sites, on the web, a check of their Facebook accounts, of their Twitter feed. You get a lot of information about the witness. Maybe not rural witnesses or poor witnesses, but certainly when you're dealing with urban witnesses and witnesses who pretend to be something that they are not, you can get a lot of information if you do background checks on the witness online by looking at their previous statements, looking at their conduct, and sometimes you will be able to tie their testimony by putting forth embarrassing questions to them as a consequence of this background test. There are many things which we learn as counsels. One of the first things that I learn before I go into a court is to know my court. Cross-examiners must also know the kind of witness who's coming to the extent possible. Of course, sometimes we are completely in the dark, But sometimes the witness has put enough information about himself or herself outside in public domain that you may find useful while attacking the credibility of the witness. How to frame questions. Again, this is something which was taught to me by my own senior. And he always said, don't get entangled in a maze of long winding questions. Make your questions short, that you understand and the other one, and the person opposing you is able to answer. Don't make long-winded questions. Don't put 4 questions into one question. Make it short, make it crisp. Frame questions to attack the witness. The minute you have long, complicated sentences, it will confuse the witness, and it introduces a scope of ambiguity in the answers. You should always try and cross-examine the witness in the language of the witness. In the city that I practice, Delhi, many of the witnesses who come are unfamiliar with English and are more familiar with Hindi. And although Hindi is not my parent language, I know enough of the language since I have grown up in the city, and therefore I cross-examine the witness in Hindi. It kind of puts everybody at ease and gives a false sense of security even to the witness. So therefore, always cross-examine the witness in the language of the witness. Unless, of course, you have no choice. Every question should relate to a specific individual query. Only ask those questions, I repeat, for which you can predict the answers. Do not ask questions for the sake of asking questions. Ask questions if it's in a murder case, in a case relating to the IPC, several kinds of questions can be asked. Was there light at the time of the occurrence? The number of persons at the scene of crime? The naturalness of the witness testifying can be tested. Was there a delay in recording the statement in the first instance? Is there any suppression of material? Is it possible to say that the manner in which the witness has sequenced the occurrence was the manner in which it actually happened? Can you give a counter theory? All of these form important elements of cross-examination. Another tip, quit when you're ahead. Very often we get greedy. So we've got a series of answers which lulls us in the state of mind where we believe we are ahead. But one of the lessons I've learned is when you've got all that you were looking for and maybe a little more, you should quit instead of probing more, and by which time the witness has got wiser and then gives an answer which will defeat the entire purpose of cross-examination that took place preceding that question, that greedy question that you asked. So I always tell my team, quit when you are ahead. I'll give a short example. In the 2G case, one of the iconic cases that the trial of which I was privileged to be part of, a very, very important witness was asked a question which should not have been asked. In his entire examination in chief, he did not testify to any kind of loss that the government suffered as a consequence of the 2G scam. And yet, the cross-examiner, immediately ahead of us, asked this question, where he said, well, is it correct that, that no loss was caused in this case? And bang came the answer, of course loss was caused. And it was elaborated further by the witness. Remember, the witness had not touched the theory of loss in his examination in chief. And yet the cross-examiner got excited, and instead of quitting when he was ahead, asked a direct question for which he got a direct negative answer. So those are mistakes something which is not testified, do not touch it. Our team was the next in line, and we were being told repeatedly by all counsels and everybody else in court that we should try and pull back the damage. We proceeded. in the manner that we had decided we would proceed and ask questions that we had come prepared for. We had the advantage of examining this witness's testimony during the Joint Parliamentary Committee in Parliament, where he had made a very, very interesting answer, where he had given a very, very interesting answer with respect to loss. So we pulled out that document right at the end, and we confronted him with what he had said in the JPC proceedings. And in the end, he looked at it, he agreed, and this is the answer he gave us. It is correct that while determining policy, government has to make a balance between welfare maximization and revenue maximization. In this case, if there was sacrifice of some revenue, it cannot be said that the government suffered a loss. So what seemed like a hopeless situation before we came on, when a direct question on loss was asked and a direct answer was given, we were able to pull back the damage because we had in our possession this witness's JPC testimony, where he had nuanced the issue with obligations of a welfare state. So these are some ways in which you can come back to a cross-examination. Confrontation, another very important tool of cross-examination, and we must always be cognizant at all times. What was the previous statements of the accused, and how should you confront the witness? Confrontation is something that is defined under Section 145 of the Indian Evidence Act. This must be read with 162 of the Code of Criminal Procedure. So confrontation is again another very, very important tool which must be adopted by cross-examiners to discredit the testimony of the witness with respect to any exaggerations or improvements that the witness has made. Attacking the credibility of the witness, if you were to examine Section 146 of the Indian Evidence Act, it specifically allows for questions to be asked that attack the credibility of the witness. Section 155 is another section that you could rely upon for purposes of impeaching the credit of a witness. Your own defense must be put forward in the form, either in a suggestive form or directly, depending upon what you can extract from the witness, while cross-examining the witness. And this defense must be consistent. From the beginning of the case till the end of the case, the defense that you take must be consistent. This is again part of the general manner in which you conduct the trial. It's not specific to cross-examination, but if you were to do it in a jerky fashion, where you put forward one defense before one witness and another defense before another witness, you will pay the price for it. So whatever is your defense, you must decide at the start of the trial, and you must be consistent in putting forward that singular defense. There are situations where you can take different defenses, but those defenses must also be interconnected in a way that it makes the entire presentation credible and trustworthy. The other part, which is very important for cross-examiners to remember, is the giving of suggestions during cross-examination. When incriminating allegations are made against you or your client in the examination in chief, you must insist that you pick up each one of those incriminating allegations and give suggestions countering those allegations. Suggestions are a very, very important part of cross-examination, which sometimes counsels tend to ignore. Because very often, especially at the appellate and the higher stages, questions are asked of us. So what is your case? Have you given a suggestion to the contrary? And that suggestion then comes to your rescue if you have done so. If you have not given suggestions to the contrary, today the law, as it has developed and evolved, tends to suggest that you are making an admission of that fact. So always remember to give appropriate suggestions with respect to certain incriminating aspects of a witness's examination in chief. And this fact has been has been highlighted by the Supreme Court in Tarun Bora alias Alok Hazarika versus State of Assam 2002, 7 SCC 39, where the Supreme Court has said you have to refute the prosecution's case specifically through suggestions, and it otherwise it will be treated as an admission. With respect to expert witnesses, post-mortem doctor, CFSL expert, DNA specialist, I think lawyers must now develop special skills, or at least have persons on board who know the subject. Very often, this is very, very technical, something that we are not trained in. And therefore, the need, if possible, only if, of course, if your client can afford it, the need to engage specialists on your team who will help you frame questions for expert witnesses, such as the post-mortem doctor, such as the CFSL expert. In a case in which my office is currently contesting a murder charge, the entire case rests on the testimony of the board of post-mortem doctors. There is no other evidence except the testimony of the doctors, where the doctors say that this particular person was strangulated, although there doesn't seem to be any evidence of strangulation apparently on the body of the deceased. The manner in which we contested the expert testimony was to keep on board a former forensic expert, a former director of a leading hospital who conducted postmortems himself, and he helped us formulate questions which attacked the testimony of these expert witnesses. So sometimes if you have the privilege of taking on board the services of retired experts, please do that, because that will help you formulate the right questions for expert witnesses. And these include witnesses who are post-mortem doctors or who are forensic experts. Are there embargoes? Are there questions that you cannot ask? Yes. In cases of sexual offenses, there are certain embargoes, and I will just quickly highlight them. Section 53A of the Evidence Act puts an embargo on questioning the previous sexual experience of a victim survivor of a sexual offense or attempted sexual offense. Section 114A states that if sexual intercourse is proved and the woman states in her evidence that it was not consensual, then the court is to presume that it was non-consensual. The burden of proof thus shifts to the accused. And finally, Section 146 states that the victim survivor cannot be asked questions as to her previous sexual experience or general immoral character in cases of sexual assault or rape. So these must be kept in mind while cross-examining witnesses who are either survivors of rape or other forms of sexual assault. Largely, this is the structure of cross-examination, and this is what we call the art of cross-examination. Nobody can really claim to be a perfect cross-examiner. We all make mistakes. We all learn from our mistakes. It's very easy to say quit when you're ahead, but sometimes you don't know when you're ahead, and you therefore end up asking the foolish question. That is something that you learn through experience, and sometimes even experienced counsels make mistakes. The idea is to minimize the mistakes you make, and if possible, pull back from the mistakes you make. I will conclude this lecture by quoting from a judgment of the Supreme Court, Mahinder Chawla and others versus Union of India, 2019, volume 14, SCC 615, where the court has said that in an adversarial system which is prevalent in India, the court is supposed to decide cases on the basis of evidence produced before it. This evidence can be in the form of documents, it can be in the form of oral evidence, the deposition of witnesses. Witnesses thus play a vital role in facilitating the court to arrive at correct findings on disputed questions of fact and to find out where the truth lies. They are therefore the backbone in the decision-making process. Whenever in a dispute, two sides come out with conflicting versions, the witnesses become an important tool to arrive at right conclusions, thereby advancing justice in a matter. This principle applies with more vigor and strength in criminal cases, inasmuch as most of such cases are decided on the basis of testimony of witnesses, particularly eyewitnesses who may have seen the actual occurrence or crime. It is for this reason that Bentham stated more than 150 years ago that witnesses are the eyes and ears of justice. I would add to it and say defense lawyers are the eyes and ears of justice. You're the last bastions of freedom. You uphold freedom and liberty. And one of the most important functions that defense counsels do in the course of a trial is cross-examination. Thank you.
Ma'am, thank you so much, ma'am. I would just invite the participants if they want to have an interactive session with you. Any of the participants, I think ma'am was really very clear. I don't think we will have any doubt about anything. Is there anything else the participants would like to interact with ma'am?
Yeah, good evening. Good evening.
Yes, please identify yourself.
Hello.
Yes,
Hello.
Karthike Kadirvel Pandian.
Yeah. I am
Yeah,
Kadirvel
you're-
Pandian from Kadirvel Pandian
Yes.
from Coimbatore Government Law College.
Your audio is clear, but your
First of
video
all, I
is
would like
not.
to thank Madam Rebecca Jean for the excellent presentation. To listen to her presentation earlier when she was giving lecture in Bangalore University Law College. My simple question or the basic question to her. The basic question is, in some of her lecture, she told, while cross-examining the witness, is it okay?
Your audio is breaking, Mr. Kadirvel
While
Pandian.
cross-examining the witnesses, she told in several meetings, first of all, we should know what are the questions not to be asked than the questions to be asked. So in this example, I would like to ask. Okay, now it is clear.
I can't hear you, unfortunately.
Yeah, Kadirvel Pandian, your audio is cracking.
Hello.
You just come again, Kadirvel Pandian. Your audio is cracking. Can you just come again with the last part of it? You are.
Okay.
Just come up with the last part, ma'am. I think only the last part.
Yes,
I think, yeah.
I just the.
Kadirvel Pandian.
Yeah. My last part is whether Madam Rebecca Zahn can tell us what are the basic silly questions that we should not ask as a fresh lawyer or a fresh advocate to the witnesses.
So I gave you the example of the 2G case, where although the witness had not, and this was a very, very important witness in the case, although the witness had not testified to the allegation of loss, which, as you know, was one of the pillars of the case. And this witness was supposed to talk about loss. He did not. He didn't say a word about loss. Neither did the prosecutor extract anything from him about loss. And so therefore, everyone should have kept quiet, because if he's not saying something, there is no need for us to stir the hornet's nest. Instead, a direct question was asked where the cross-examiner said, so you agreed there was no loss in this case. Now, he wasn't going to agree to that. So that was the reason why I gave that example. When a witness is not testifying to something, there is no need to ask a question about that. And even if you were to ask that question, don't ask a direct question. So there was no loss. Do you agree with me? That's not the kind of question you can ask, because he's going to come back. He's a senior functionary of the government. He knows what the case is all about. And he's going to come back and say, of course there was loss. And that's exactly what happened. Luckily for us, we had we had other documents where he had nuanced the concept of loss. And he had said that sometimes governments knowingly, in a welfare state, take on the responsibility of loss, and that can't be called a financial loss. So we were able to nuance it. So that is why I gave that example. Direct questions which go against the grain of evidence given by the witness, and which the answers to which can be extremely harmful to your client, must never be asked.
Ma'am, thank you so much. I think there's yet another person, Sridhar Sai. Sridhar? We are not able to get any other person who would like to interact with ma'am. Ma'am, I think you were very clear about everything, so there's no interactive session at all. Sridhar Sai Alavandar?
Yes, ma'am.
Sridhar, I think you want to ask ma'am something?
No, I don't want to. I'm just joining the meeting.
Oh, okay.
Thank you.
Anyone else? Ma'am, thank you so much. It was really a enlightening one, ma'am, for at least persons who are on the basics. Like certain people, we won't even know the basics of cross-examination since they would not have been into it. It was so nice of you, ma'am, to spend your valuable time here and enlightening us on the art of cross-examination. Ma'am, and then one small thing, you are a person who is, no, this is out of the context of art of cross examination. We have heard so much about you. You are a person who condone the death penalty to take place in any such system. So you, ma'am, a few lines about it. I know it is out of the context. I'm taking you by surprise, but then there's nothing surprise for you, ma'am.
I oppose the death penalty. I oppose it morally, I oppose it legally. I believe legally that our criminal justice system is so broken that it can never ever be conclusively established that somebody committed a crime. I will only give the example that of a recent case in the Supreme Court, Ankush Maruti Shinde, and I would request everybody to read that case, versus State of Maharashtra. It was a judgment of which was authored by Justice A.K. Sikri, in which these young men of a nomadic tribe in Maharashtra were convicted and sentenced to death. In appeal, their conviction and sentence was upheld. In the Supreme Court, in the first instance, their sentence was upheld even without issuing notice to them. And then in review, the Supreme Court looked at the case afresh and came to the conclusion, after examining the evidence, that there were so many gaps in the evidence. And indeed, there was fabrication which was established on the record, that they could not, by any stretch of imagination, convict them to death, convict them of any crime. They went ahead and acquitted them and ordered that compensation be given to each one of them for the 16 years of incarceration that they unjustly suffered. This is the state of our criminal justice system. Quite apart from the moral angle, the state does not have the right to take life. I believe, even legally, it is never possible to conclusively prove in the system that is so broken as ours. And unless we fix it, it is very dangerous to go down that path. Internationally, 3/4 of the countries in the world, in the democratic world, have abolished the death penalty as being inhuman. As a humane society, as officers of the law, we must uphold that principle. And therefore, I oppose the death penalty.
Hello.
Hello.
என்னங்க சுத்தமா ஒண்ணும்.
Hello.
Yes, you can go ahead.
Very good evening, madam.
Good evening.
Good evening.
Very excellent and elaborate.
Ma'am, can you hear, ma'am?
Yes, yes, I can.
Am I audible, madam?
Yes.
Very good evening, madam. This is Anand Shivakumar from Chennai, madam.
Good evening.
Very excellent session, madam. Very elaborate. You have taken and taught us the art of cross-examination, which we lack always, whenever we always stuck somewhere during the process. Thank you so much, madam.
Thank you. Thank you.
Ma'am, only one short question I would like to seek your expert opinion on the same. Two questions I would like to ask. First being the expert evidence. Whenever we do the cross-examination with the expert, especially with the doctors, majority of the people may not be in a position to afford to take the expert. Is there any way or is there any provision wherein the government or the legal aid can pay to get an expert to cross-examine the doctors or an expert?
I think the job of cross-examination must be ours. I don't think a doctor or a forensic examiner knows how to cross-examine. What I was suggesting was that if a particular client can afford it, and it is money in a country where most of our clients are poor, it's a very onerous thing that I'm saying. But if a client can afford it, if we have a technical expert on our side to help us frame the questions, it would be good. As of now, there is no provision whereby we can ask the government to pay for it. The government barely pays for legal aid. They are hardly going to pay for the services of an expert on a defense team. So I don't think that is something which we can expect to happen. My response is, even if you're not able to get an expert on your team, there are so many books on medical jurisprudence, etc. And very often, in the older days, we used to rely on those books for purposes of cross-examination. It's only now that we are relying on experts because everything is now freely available. So it's possible for us to ask the state to pay for an expert, but it is certainly possible for us to ask our client to pay for the expert if he can afford it. Or we go back to the traditional way, and that is dig into books and find out questions.
Thank you so much, madam. One more question, one short question.
Yes.
How to handle this hostile situation, madam? Because they turned hostile, the witness.
How to handle? You're asking from the point of view of a complainant, or you're asking from the point of view of an accused?
Complainant.
Yes, because an accused would be quite happy if a witness turns hostile.
That's what it is, madam.
It's a problem. I'm also a prosecutor in some cases. And I think the problem is twofold. One is that very often the police record statements which the witness actually has never given and is surprised that such a statement has been recorded. So there's a lack of transparency in the way investigation is conducted in our country. And the second is that the witness is bought over. Now, largely it is the second one which is all pervasive and prevalent. And this requires a level of honesty from all concerned, which is something which is missing from our national fiber and character. And I hope that, the level playing field is restored, that both sides are honest. The prosecution is honest and the defense is honest. And no one needs to subvert justice by resorting to tactics like buying over witness. I hope that a time comes soon where we don't have to do that.
Thank you so much, madam. One last question. The government is spending a lot of money on witness protection program. That's what they say. Yes. Especially in India, if you are aware, latest also,
yes,
the victim has expired. No, she got raped and then finally she expired. So, what will be your action plan, or what is there any recommendation to our commissioner or whatever to witness protection?
Yes. It's a very good question. I don't think enough is being done for witness protections. While there is a lot of lip service that we are spending money on witness protections, witnesses are left to themselves. Even as a special public prosecutor that I've been appointed for in a case, I don't think the police has any interest in the witnesses. It is my effort and the effort of my office which makes sure that all the witnesses are come on time, they know what they're speaking about, and they know the structure of their case. The police leaves them. So I don't think enough is being done for witness protection. Speaking for Delhi, there's an excellent thing that was done by our former acting Chief Justice, Justice Geeta Mittal, where she ensured through her intervention that special witness protection rooms, vulnerable witness rooms they were called, was created in all our district courts. And the manner in which these operate, the witness comes in through another direction. The witness has no interaction with the accused. The witness is made comfortable, and especially juvenile witnesses who are very vulnerable. These rooms, this program has been quite successful. I hope that experiment is replicated in the rest of the country.
Yes, sir. As the government has given any specific provisions or order or some kind where it can be done across India?
Because these are administrative decisions that individual high courts have to do. So maybe you could suggest it to your high court.
Thank you so much, madam.
Thank you.
Thank you for enlightening us, madam.
Thank you very much.
Thank you. Wishing you a great day.
Ma'am, if we are not taking up your time, there's one Divya Dinesh who would like to ask you certain questions, and there are two more in the chat, ma'am. If I'm not taking your time, ma'am.
No, I can take some of questions.
Yes, sorry, ma'am. Divya?
Yes, ma'am.
You can go ahead, Divya.
Good evening, ma'am.
Good evening.
This is Divya from Chennai.
Yes.
I'm a very young lawyer, ma'am, and my question is very, very general. I had this question for a very long time. My question is pertaining to section 313, ma'am, wherein it is the accused, it is the examination of the accused on the commission of the crime. My question is in relation to the Constitution, Article 20, Clause 3. Is it like, Section 313(4) says that the answers given by the accused may be taken into consideration and it can be used against him. Is it against Article 20, Clause 3, ma'am?
Not really. It's not a statement under oath, if you know it. It is a statement without oath.
Yes,
and there is enough law on the subject, judicially determined, where the Supreme Court has held that simply because you say incorrect or whatever, it will not be taken against you. I think the value of 313 is the fact that at the end of the trial, the court, you see, not everybody, I'm looking at it very differently. Not everybody wants to be a witness in his or her own case. Not everyone wants to invoke 315. Indeed, in most cases, it's a dangerous thing. However, an accused may have a side to his story which needs to be told. And I always view 313 stages as more than idle formalities. I view it as a very, very important stage in a trial where the witness has the protection of not being administered oath and yet can put forward his or her side of the story. I have used it very effectively, and I suggest that you do the same, because without putting the witness on oath, you put forward a story which can be linked to your general defense, which can thereafter be linked to any defense witness that you may produce. As far as your question about answers being used against, unless there is a patent falsehood, which is apparent on the face of the record, which is absolutely and undeniably false, courts have been very liberal while interpreting the section.
Thank you so much, ma'am. Thank you for enlightening us. Thank you.
Ma'am, there's one Vimal Mohan who would like to ask you about hostile witness, because that's there in the chat box. Vimal?
Yes, ma'am.
Are you able to hear me? You can ask ma'am about your doubts. You have included that in the chat box. What is the evidentiary value? You can ask her straight away. Vimal?
Very good evening, ma'am.
Good evening.
Ma'am, what is the evidentiary value of a hostile witness, ma'am?
Of a hostile witness?
Yes.
Is that the question?
Yes.
Yes, ma'am.
Yes, okay. So typically, we'd like to believe that a hostile witness has no value. He's turned hostile, the matter ends. But there are many ways in which you turn hostile. You may not turn hostile to the entire case of the prosecution. You may admit to some parts of the prosecution case and turn hostile and not admit to some other parts. So it really depends upon the nature of the evidence the hostile witness has given. The Supreme Court has time and again said that they will not discard the testimony of a hostile witness simply because the witness has turned hostile on some aspects of the case. Where the witness has been consistent with the prosecution case on other aspects, courts look into their evidence. Of course, it's a matter of argument as to whether that witness is a witness of credibility. That's something that you have to develop as an argument, that because on material facts the witness has not supported the prosecution case, therefore the credibility of this witness is questionable. That is a question of argument. But the law on it is very clear that a hostile witness cannot be condemned merely because he's turned hostile on some aspects of the case. If there are other aspects of the case where he has not turned hostile and has supported the case of the prosecution, his evidence can be considered.
Thank you.
Ma'am, there's one more Ram. He wanted to know, he wanted you to throw some light on cross-examination of child witnesses. Ram, are you there? I'm not able to look. Ram?
Good evening, ma'am.
Yes, Ram.
I request ma'am to throw some light on the cross-examining of child witness, ma'am. That is my question.
See, firstly, with respect to child witnesses, the court has to certify that the witness has enough understanding to take the stand. And without that certification, that witness will not be put on the stand. Let me give you an experience in one of my own cases. It was the precursor to many of the amendments that were later on made, both in the IPC as well as it had some relevance to POCSO. The child witness, we got an order from the High Court. The witness was a young child, he was a young boy, who had alleged that he had been sexually assaulted by someone in his school. We got an order in the High Court, and I'm talking about the mid-90s, when none of this, or maybe later, late 90s or something like that, when most of these beneficial provisions had yet not come. But the Honorable High Court of Delhi made it clear that the witness must be examined on a day when there are no court proceedings, and so he was examined on a Sunday. The witness sat next to the presiding judge. The witness was asked questions by the presiding judge, that is, the defense counsel gave chits to the presiding judge, and then the presiding judge asked the question. There were many questions that were put to the witness, but it was done in a very congenial atmosphere after the judge made the witness feel very safe and secure. I think even as defense counsels, we must not lose our humanity, and we must not forget the fact that we are citizens and members of society, and we must not pounce on younger children in a way that will rattle them, because they are young, they are impressionable, and therefore we must be very conscious about our responsibility while cross-examining child witnesses. This is not to say that the testimony should go uncontested. I'm only stating that there must be dignity in the proceedings, and we must cross-examine the witness in a humane and dignified way.
Thank you so much, ma'am.
Thank you.
Great.
Ma'am, one last question. This is from me, ma'am. Now, when we cross-examine, of late, ma'am, the courts, when they record evidence, they don't record our questions. Only the answers are recorded. That is how it's happening. So, my personal feeling is only when the question is recorded, ma'am, and the answer to it is recorded, we would know what is the intention of the defense and what was given. So your opinion on it, ma'am, without the questions being recorded, only the answers being recorded, it could be read otherwise, because you won't know what was the defense wanted to prove out of that question?
So this is a double-edged sword. There are times when I insist that the question be recorded, and it is recorded. But once the question is recorded, you are bound by that question. You don't get the opportunity of saying this was not what I asked, or this answer came from somewhere. Then it becomes crystal clear. So as a defense lawyer, you'll have to think through this, whether you actually want the question on record or whether you don't. There are times when the witness is acting tough or the prosecutor is interjecting needlessly, when we insist that the question be recorded so that the answer is given in the correct form. But where the evidence is going in an uninterrupted manner and perfect sense is being made in the transcript, I don't think there is need for insistence of the question being recorded.
Ma'am, thank you so much, ma'am. In spite of your hectic schedule, the courts having been reopened, even though it's virtual courts, having spent your Friday weekend with us with your valuable inputs, ma'am, we are really very grateful and thank you so much.
Thank you so much.
Mr. Ravindran will also.
Ma'am, thank you so much, ma'am.
Thank you.
I know you are very busy, but in spite of that, you have dedicated time to us.
I could not refuse Mr. Ravindran when he asked me to do this webinar. I readily agreed. Ravindran has a long journey of working with me. We work side by side in some cases, and so it was a privilege addressing all of you. Thank you very much.
Hopefully, our journey will continue, ma'am, successfully.
Thank you so much.
As earlier. Thank you so much, ma'am.
Thank you.